Good morning. Are you Demarcus Sagal? And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Senegal, in cause number 20-33924, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2020 for the offense of deadly conduct, discharging a firearm, a third-degree felony, and that was a 10-year term in prison that was probated.
Enjoying these real courtroom stories? Subscribe for weekly episodes packed with justice, drama, and real-life courtroom tension.
For 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample June 2nd of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample July 3rd of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample August 14th of 2025 that also tested positive for cocaine. Is that true or not true?
True.
And then count 4 alleges that you're behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Senegal is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I may have gone over that with you, but I don't think I started that in 2020. But because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff, and thank you for being here for probation as well. How do you say your first name?
Isis.
Isis. And your Isis Traddles?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
She will, Your Honor. Oh, I gave it to you.
I got her. Ms. Traddles, in cause number 25 DCCR 1478, you're charged with a state jail felony offense of injury to a child from July 21st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, which would include entering and successfully completing an anger management program. You understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Judge, I'm sorry to interrupt the plea. Your Honor, I just realized that there's information in my file that indicates restitution for the hospital bill for the child. I shared it with Mr. Parker. It's $346. I don't know if we want to put this on hold.
Well, so I'm going to reset it for sentencing, and that can be confirmed with probation between now and sentencing. And And then just make sure they know about the restitution amount. So if there's any restitution between now and sentencing, they'll get that figured out, and it will be ordered if there was any restitution. You understand?
Oh, so I thought you say I'm gonna have to pay that?
What, I'll tell you, they're gonna look into that, they're gonna reset.
They're going to look into it. If there was something that had to be paid or is owed because of what you did that insurance didn't cover or whatever it is, then yes, you're going to have to pay it. And I'm going to make that notation on the agreed punishment recommendation that I've said restitution to be determined, if any.
Your Honor, we're requesting a personal bond.
Hold on,
also.
let me get there.
I'm sorry.
Okay, did I already ask about,
Immigration. citizenship.
Immigration.
That's what you left off, Judge.
okay, state tenders number one,
No objection.
it's admitted. Any evidence that Ms. Triddles is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Coleman, what is your position with regard to bond?
The state's unopposed to either lowering the bond or a personal bond. Judge, she has no criminal history. In fact, information in my file indicates that she was cooperative with law.
So where is the child now? Who's he living with?
And his mom.
Okay, so this wasn't your child?
No, ma'am.
Do you have any children?
No, ma'am.
All right, so here's what I'm going to do. I'm going to reduce your bond to $1,000. I'm going to make that a personal bond, which means you do not have to pay any money to get out. If you don't show up to court, you're going to have to pay the $1,000 and they'll come after you. But you'll just be released today. But there's some very important things about that. So the first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If for some reason it's later in the day, then go first thing tomorrow morning. But if it's not, then go straight there this afternoon. You'll get some paperwork today that tells you where to go. If for any reason you don't follow through with that report, then you run the risk of me not accepting the plea agreement and things could be much worse. You understand? Also, if you're arrested for anything between now and the time that we come back for sentencing, you run the risk of me not accepting the plea agreement. You understand that also? And then finally, between now and sentencing at least, I am going to order that a condition of your bond is that you not have any unsupervised contact with any child under the age of 18. Now, that obviously may change in the future, but just for between now and then, I don't want any unsupervised until I know what we have in place and I can find out more about the. All right, sir. You're Derek Williams, right? Mr. Williams, you were given an opportunity to visit again with Mr. Lewis about what your position is with regard to what we went through. The possibility, if you go to trial, is potential for 2 to 20 in prison if you're found guilty, and that the state had offered a 4-year term if you wanted to enter a plea of guilty. And so, what do you want to do? You want to go to trial. So there's a rejection that you need to sign with Mr. Lewis. Y'all get that signed. I'll call you right back up here and we'll get your case set for trial. I do want to make sure you understand though, I know we already went over this, that this offer will not be accepted after today. If you're not guilty, that's fine. That's what juries are for. But I don't want you to think by putting this off, you're going to get some better deal. Okay. All right. I'll hold it while y'all do that. I'm sorry?
I was hoping that we should plea deal today.
Well, the offer is what the offer is.
Understood.
Okay,
Yes.
all right, y'all do that rejection, and then I'll take care of it. Mr. Galmore, you got Melissa Taylor.
Judge, I filed
He was busy waiting his turn.
I was looking at my phone.
I know.
I filed a motion to modify probation as well on another case that she has. We were having problems with e-file yesterday, so it may have been very late in the day. I don't know if it made it, but it's.
I received it this morning, Your Honor. I can tell you what it is. And we kind of discussed this with Ms. Simmons earlier this morning. Ms. Taylor pled a couple months ago on, I think, 2 other cases, and got probation. She was ordered to safety. Before she could get sent to safety, this case got indicted and they kept her here. This case was indicted about a month ago, first week in November.
Okay, Offense date of
March predates what we did before.
predates it, okay.
It was part of the backlog of testing for the lab.
Yeah, and so the agreement on this one is,
To run concurrent with what she's doing, which, I think this is a 10-year deferred, concurrent with what she's already doing. Mr. Galmore's position is that since she's had to wait a few extra months in custody and not able to go to safety as ordered, he's asking that safety condition be switched to maybe ISF or something else if the court deems appropriate.
so what I would do at that point is it would get reset for sentencing and they would have to do a new substance abuse evaluation. If you want me to, I need probation's input. If their recommendation previously was for safety, then she hasn't received any treatment. I understand that she's been in custody, but that's not treatment. And so if she's going to get a probation on a possession to go along with that, there's going to be some treatment, and I would
Right.
anticipate it would be in custody treatment.
And that's what my motion on the, motion to modify probation was, suggested was an alternative treatment program that just may be shorter. I think the real reason for the argument would be the fact that she is farther removed from her drug use at this point than it was originally considered.
I would consider ISF,
Well-
but I'm not going to do outpatient. I think we need something with 2 felony probations that's a little more intensive.
ISF the shorter ISF program would probably be about the same amount of time that was originally planned for her to be in custody anyways.
Right.
And so that was one of the requests
Okay.
that my motion made in the motion to modify. And then we left the treatment plan on this plea up to the court.
So is there any reason to get even an updated pre-sentence report? I can just
No,
go
Your
ahead
Honor.
and do all of this.
She's been in custody this whole
Okay.
time, so there's
Sure.
nothing that's been changed.
Right.
I know of no major disciplinary problems or anything like
yeah.
that, so I would ask the court to go forward today.
Okay, all right, let's take care of the new case and then we'll discuss the modification. Then, you're Melissa Taylor.
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Taylor, in cause number 25, DCCR 1693, you're charged with a third-degree felony offense of possession of a controlled substance from March 9th of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for a 10-year deferred probation. Is there no fine on this one?
I'm okay with waiving the fine. Your Honor,
All right,
since
there
she's
would be
already
no
done
fine on this case, and you would be required to follow all of the rules and conditions of probation, which, as you guys have said, is unagreed as to treatment, but that we've talked about. What I'm inclined to do is the substance abuse track of the ISF program. Is that your understanding? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Taylor is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I am going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You're ordered to follow all of the rules and conditions of probation, which include entering and successfully completing the substance abuse track of the ISF program. In addition, as your follow-up treatment, when you get out, you will be required to enter and successfully complete the JCDI program. So you're going to get out, you'll have all the tools, you're going to get tools while you're in custody, you're going to get out, you're going to have even more tools so that you can be successful and get off drugs for good, be a productive member of society, and not end up with felony convictions on your record and going to prison. And if you do all of that, just like we talked about in the other case, this is a great opportunity because you don't have the conviction on your record. If you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition in this case, you'll be brought back into court, you could be found guilty, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you, in that case, the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. Yes, ma'am?
May I speak?
Let me, hold that just a second. Let me take, because I'll get sidetracked and then I won't do what I need to do legally. So now, for probation, in cause number 24, DCCR 2311, I am going to grant that motion to modify the probation order to change that from SafeP to ISF, substance abuse with JCDI as aftercare. 24 DCCR 2311.
Judge, I think there may also be another probation that she's on, a different cause number.
I'm not sure.
I thought we pled her to a state jail and a
Look,
higher level
please.
felony. I just don't want, I don't want to get skipped over if there's another.
If
cause
she's on probation for more than that one, if there is another, and we did, then the same order goes for all. If it was SafeP, that can be,
number. No, just this one or two.
switch from SafeP to ISF substance abuse with JCDI as a, the problem is if it's do y'all think there's one? Because it might be the time
I
that
did
she's
not
on
think there
probation
was
could be an
one,
issue.
but I
Okay.
could be wrong.
Okay, we'll double check it. If she is, that'll be a condition. It'll be switched from SafeP to ISF also. Okay, yes, ma'am.
Yes, ma'am. So I have been incarcerated for the last 8 months in Jefferson County Correctional. During the last 8 months, I've held a trustee position for 6 of those 8.
In this video, Judge Raquel West oversees a series of high-stakes felony hearings inside a Texas courtroom. Demarcus Sagal faces probation revocation after discharging a firearm and repeatedly testing positive for cocaine, showing just how unforgiving probation violations can be. Isis Trattles stands accused of injury to a child as her case moves closer to sentencing and restitution. Derek Lee Williams must decide between accepting a plea deal or risking trial, where a conviction could mean 2 to 20 years behind bars. Finally, Melissa Taylor's repeated probation violations and controlled substance charges lead to strict modifications, including intensive substance abuse treatment. Across every case, Judge West balances legal procedure, accountability, and real consequences, revealing the harsh realities of the Texas felony court system. For more real courtroom stories and intense legal drama, subscribe and stay tuned for every shocking ruling and emotional moment.